Hey everybody, today we're going to be looking at the First Amendment and the Establishment Clause, which is basically what can the government do in regards to religion, not so much your practice in it, but in how they support or don't support religion. So, just to be clear, what is the Establishment Clause? Well, if we look at the First Amendment, the very opening lines give us that bit. Congress shall make no law respecting an establishment of religion. If we kept going in that, it would say, nor the free exercise thereof, and that's the free exercise clause, but we'll get to that one later. Right now, we just want to look at what is it that prohibits the federal government and the state government from not only creating a new state church, but also in what they can require of their citizens. So, if we go back in time a little bit, we remember our discussion on Barron versus Baltimore, that um, that case where Marshall ruled that the Bill of Rights really only applied to the federal government and the states weren't bound by it. What that had meant is that a number of states could and did do things that we would say today violate the Establishment Clause. So I think it was Massachusetts was still requiring taxes to be paid to support an established church up through at least the 1830s, maybe into the 1840s. We get to the early 1900s. A number of states start passing a law requiring, Bible reading and prayer. Kind of this is along the same time period when, we get the Scopes trial in Tennessee, where the state of Tennessee is going to outlaw the teaching of evolution and mandate the teaching of creationism. Um, and so that had pretty much been left up to the states, and they had gone with it. And so the first important case we get in looking at the Establishment Clause and essentially our modern understanding of it comes in 1947. It's there on the screen. And that is Everson versus Board of Education. This is a case that comes out of New Jersey. And a New Jersey law was passed, and it allowed school boards to essentially reimburse parents for, or rather, reimburse local school districts for the transportation cost. And what this really gets down to is a lot of students were going to private religious schools, in this case, mostly Catholic, um, and they would take public transportation to get to school. And since the state was providing transportation, they decided to cover these costs. And of course, that's what's going to get challenged. And what actually happens in this one, we tend to think of cases like this where the law gets overturned, but in this case, the law actually is going to get upheld both at the local level, the appeals level, and all the way up to the Supreme Court. But what's important in this case is how the court rules on it, and simply the fact that the court does choose to rule on it. And they give us an important understanding of the Establishment Clause and how we're going to look at it. So let me bring up real quick this bit. So this is an excerpt from the majority opinion. It was written by Justice Hugo Black, who's one of the really critical figures in constitutional history, Supreme Court history. And so let's take a read. It says the Establishment of Religion clause of the First Amendment means at least this: neither state nor the federal government can set up a church. Now, let's pause for a second. Pretty much everybody agreed with that one. Even the dissenting judges, judge singular on this case, probably or did go along with that idea. And pretty much everybody had gotten on board with that one a while back. But Justice Black is going to go a little bit further, and we're going to see some lines that actually apply specifically to this case, but also will apply to later cases. Okay, so neither state nor federal government can pass laws which aid one religion, aid all religions, or prefer one religion over another. No person can be punished for entertaining or professing religious beliefs or disbeliefs. No tax in any amount, large or small, can be levied to support any religious activities or institution, whatever they may be called, or whatever form they may adopt to teach or practice religion. Now, that one would apply to the current case, right? Because there's a tax involved. Like, where's the money coming from to pay for all this? Well, it's going to come from the taxpayers of the state. But the court's actually going to say in this one is that the money that comes from this is just general education money. Like, kids are going to go to school, and the school board is going to pay for transportation to school. So this actually, they would say, isn't, in this case, aiding any religion. And then it's the last line here that we're going to say is a really important one because it affects for a lot of people in the United States today how we understand the Establishment Clause. In the words of Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. If you haven't heard those lines before, it won't take very long getting into establishment and free exercise cases where you're going to see that a lot. That line actually comes way back when from Roger Williams, but Jefferson is going to respond to a letter from a group of Baptists, the Danbury Baptist letter. They were writing from Massachusetts, complaining about being taxed, and those were some of the words he used, basically arguing why they shouldn't be, and that he essentially supported them, and nothing really came of it. But that idea that there is a wall of separation between church and state becomes a really important and a really powerful idea as we move forward. And Justice Black and other justices going forward or further in all this, like they discuss the idea that we're a pluralistic society. What that means is we have a whole bunch of different religious groups. And even if you think, just purely within Christianity, there's a whole bunch of different denominations and subgroups that have some really strong differences. Wars have been fought over this, and they actually make that point. And so the idea was you needed to keep, generally speaking, the government as far out of religion and vice versa as you could. So those are important lines, even if this maybe isn't one of the biggest cases in history, because essentially it's just upholding a law. The really important case that you need to know is this one, Engel versus Vitale. This is a 1962 case, so we're getting into the time period of the Warren Court. We'll talk about the Warren Court, Chief Justice Earl Warren later on. And so the basic facts of this case come down to this, is that New York State had passed a law in 1955, so think height of like Red Scare and Cold War and all that, that had allowed for and called for, but not required, school districts or schools' classrooms to start the day with both the Pledge of Allegiance and this 22-word prayer. They described as a non-denominational prayer. You see it on the screen there. Almighty God, we acknowledge our dependence upon thee and beg thy blessings upon us, our parents, our teachers, and our country. Amen. Good King James English there, huh? So, laws passed in 55. By the time we get to the early 60s, you get a student come into the school system, and they and their parents decide to challenge this particular prayer that they're being essentially subject to. And it's going to work its way very quickly up to the Supreme Court. And so the question before the court, and you have to know the question, is school-sponsored non-denominational prayer in public schools unconstitutional? And the Supreme Court's going to say yes, that essentially you are, the state is using its power in sort of a coercive manner to force religious practice and to force religion on its students. And so you actually see, I think it's the New York Times there, off to, I guess, the side. 6-1 decision. And this was considered, a pretty significant deal at the time because, well, lots of states, at least 20 some odd, had various laws, maybe more than that, actually had laws that either required or strongly suggested that this would take place. We really need to put the Engel versus Vitale decision along with the Abington School District case that comes the next year, because it's very similar but different enough. And so in this case, it wasn't just prayer time, it was Bible reading. And so in this case, we had a state statute that required that 10 verses from the Bible be read without comment at the start of every class period. And is that constitutional? And again, based off of Engel, so we see the power of precedent already, they're going to say, no, that's not legal. And essentially, we're going to see a whole series of cases that are going to keep sort of building on this. And so if we take a look at those real briefly. So you see just 3 cases. These are some of perhaps the more well-known ones. The general theme is going to be this for how we understand establishment cases. That pretty much any time, particularly if we think about schools, because that's where it tends to play out in the media and in our modern cultural fights a lot. pretty much any time the school is using an official event or school leadership, whether that's administration or teachers, um, to deliver prayer or religious instruction or Bible reading or whatever it may be, um, or they're using required events or even just official school events, those are all going to be struck down. And that's really what you see in these three cases. And, we've got them from basically three different decades, although, a little bit close there. 1985, Wallace versus Jaffrey, that struck down a state law that set aside the first minute of every class period or every day for prayer or meditation. In 1992, a middle school graduation ceremony that had clergy-led prayer was ruled against. And then several years later, the Santa Fe Independent School District case that made it to where student-led prayer at a high school football game would be considered illegal or would be violating the Establishment Clause. And in that case, even though it's student-led, it's a school-sanctioned event. It's a school-funded event, so that's really a no-no. If you look at the image on the screen, that's from a fairly recent, I think it was, news story. And you see there, high school students stopped from praying. And so while the school can't force or require you to participate in really anything that's religious, they also can't stop you from doing those things on your own. And we're going to talk about free exercise more later on, but generally speaking, just giving you a little preview because I really love previews, you're allowed to practice your religion as long as the school isn't forcing it. And the idea in all of this, even if, especially maybe, if you live in a part of the country that's very religious, or you're in a school that, everybody goes to church there, that's fine. But essentially the state using its power, we would consider that coercive. That's by force. You're required to sit there. You're required to be there. And so the court has increasingly understood that as violating the Establishment Clause of the First Amendment, that it is aiding and setting up a particular religion, or in this case, simply setting up a religion in general, especially if we go back to how Justice Black understood things in that earlier case. So hopefully that all makes sense. Okay, last case you need to know. This is not one of the key cases, but just if we're thinking about the AP government exam, for those of you here to learn about that, so my students, Lemon versus Kurtzman has been a question historically. And so this is an important case for how do we understand and how do we evaluate whether or not a law or statute or an act violates the Establishment Clause or not. And this kind of gives us a rough outline. And so basically what we have is two cases that are working their way through the system at about the same time. One's coming out of Pennsylvania in 1968, and one's coming out of Rhode Island in 1969. And they both basically do the same thing, and they both are going to use state funds to pay for private schools, materials, and in the case of the Pennsylvania law, it also pays for the salary of teachers. And the idea was to pay for secular teaching. And so this wouldn't be pay any money for religious classes, but let's just say a political science class, a government class. It could pay for the salary, it could pay for books, it could pay for materials, things along those lines. And essentially the state is saying, we have a vested interest in the education of our young people, and so we're going to pay for these things. And of course, this is going to get challenged in both cases. And I believe it's the Rhode Island law gets struck down, but the Pennsylvania law gets upheld and in the appeals courts. And because you have two appeals courts with two different decisions on basically the same issue, the Supreme Court has to step in. And so the Supreme Court's going to step in, and in 1971, they give us the ruling. And so you got the background. And so the question here is, do statutes, right, laws, that provide state funding for non-public, private, non-secular, religious schools violate the Establishment Clause of the First Amendment? The answer is going to be yes, they do violate it. But in giving us this ruling is that the court establishes something that we're going to eventually refer to as the Lemon test. And it's a three-part test, and you see the three parts there on the screen that say, that we can use to evaluate this. And so does the law have a secular purpose, right? And so in this case, is paying for educational materials secular? Yes, probably. Does it aid or inhibit religion? And actually, the court didn't step into this one on this particular case because they went straight to point 3. Does the law create excessive government religious entanglement? And what the court said is that the way the Pennsylvania law was written, and actually the Rhode Island as well, is that they required, in order to make sure that these were secular classes, that there wasn't religious instruction, that was going to require a certain amount of government oversight. Well, how much government oversight? Are they going to have to start sending in, inspectors to make sure? Does this get to the point where you have the government essentially forcing certain curriculums onto private schools? And the court's going to rule strongly that, yeah, this was excessive. This was too much entanglement. And so therefore it struck down this law. And so that becomes really the standard for establishing that. Now, if we start talking about some really current cases, the Supreme Court doesn't actually really base a lot of decisions off of this one. There's a recent court case, the Masterpiece Bake Shop case, about a cake shop in Colorado that ended up in front of the Supreme Court because they would not bake a custom cake for a gay couple's wedding. And the state of Colorado had ruled against them. And anyways, it worked its way all the way through. And then there were some other cases. And basically the justices kind of sort of disregarded, essentially said the Lemon Test wasn't a real thing, but we consistently see lower courts reference it for their deciding of cases. And so 3 parts. Law has to be secular, can't aid or inhibit. So go back to our earlier one, right? The Emerson case. New Jersey paying for transportation, even if that was to a religious school, does that aid like religious institutions? And the court at the time at least said, no, it doesn't. But does it create excessive entanglement? So that becomes our new standard. So hopefully all of that made sense.